Hello, I'm Dan Marr from Hamlin Kerrigan, and today I'm going to be talking about individual liability for employment discrimination and retaliation. New Hampshire has a discrimination law that prevents you from retaliating or discriminating against somebody because of certain protected classes. That can be race, it can be disability, gender, and a variety of other issues. Individuals now, because of a clarification in 2016, can now be individually liable for both employment discrimination and retaliation, and that's a very important distinction that people have to understand now. There is a case, basically the case was the Equal Employment Opportunity Commission versus Fred Fuller, and the New Hampshire Supreme Court has ruled that in situations, individuals of a company, an LLC or a corporation, can still be individually liable even though the company is the one who discriminated if they aided and abetted in discrimination, or they were the person, the individual for that company that was retaliating based upon that. Now in that particular situation, it was a fairly egregious facts, and it's in the news and people can look at it. But think about the other option of something that's less egregious. Think about the circumstances upon which you're a mid-level manager and you're told by your boss to take some action against an employee. Maybe it's a situation where, say, Jack and Jill are working in the workplace, and Jack is doing questionable things to Jill, maybe trying to get her to go out on a date or actually making vulgar comments to her, and Jill complains about it. And the boss goes and says to the manager, you know what, it's a he said, she said, I don't want to do a discrimination, a sexual harassment investigation, fire them both. Well, Jill is going to have a claim very clearly now, not only against the company, because she was retaliated against for raising a sexual discrimination claim, and she'll have one against the owner, who's the one who made the decision, but that mid-level manager can also be liable under that law, because that person is retaliating. He's part of the retaliation process, so that could be a very important consideration for mid-level managers who are just following orders. Now, in a normal situation, if you have a larger employer, a company that has actual assets, that company is going to have to indemnify that mid-level manager for following the orders. But what about the situation when the company is in a marginal situation and they can't, maybe it's a restaurant that's not doing that well to begin with, and this might be the thing that makes them go over the edge and close down. Well, not only is the owner that thinks that maybe he's protected because of the LLC and the corporation liable, but that mid-level manager could be liable too. So in those situations, it makes a lot of sense that if you're in a circumstance where you might be asked to be part of that stream of any type of employment discrimination or retaliation, you should speak to an attorney. If you have any questions more about this, you can check some of our actual blogs. I have several blogs at our website of hamker.com, hamcare.com, or you can look at our podcasts. We have podcasts from our radio where Kevin Rossio and I do radio shows on WFEA 1370 AM and 99.9 FM. And you can also, checking with that, and you can also contact me at 603-883-5501. Look forward to hearing from you.